elections as an independent candidate. And D, Honorable Cynthia Mamile Morrison, Member of Parliament for Aguna West, who was elected on the ticket of the MPP, had filed with the Electoral Commission to contest the upcoming 2024 parliamentary elections as an independent candidate. In the light of these developments, the Honorable Minority Leader invited the Speaker to declare the seats of these 4 members vacant in accordance with Article 97(1)(g) and 97(1)(h) of the Constitution 1992. According to his submission, if these seats are declared vacant, the resultant effect on the composition of this House would be that the NDC would have 136 seats, while the MPP would have 135 seats, thus making the NDC the majority party in Parliament. This statement sparked intense debate in the House, with members raising questions of constitutional interpretation and the role of the Speaker in the enforcement of Article 97 of the Constitution, particularly in the matter of the vacation of seats by members of Parliament. It is therefore incumbent upon me, as Speaker of this House, to address these issues thoroughly. In doing so, I am simply applying the provisions of the Constitution 1992, Parliamentary Act 1965, Act 300, the Standing Orders of Parliament 2024, precedents, and established legal principles. The issue of interpretation and enforcement of the Constitution lies in the bosom of the Supreme Court and not that of the Speaker. And so I proceed to tell you my understanding of Article 97. Honorable members, at the core of the Minority Leader's statement are the provisions of Article 97(1) of the Constitution of Ghana, 1992, which govern the circumstances under which a member of Parliament shall vacate his or her seat in Parliament. The relevant subclauses of the provision read as follows. Article 91 states, a member of Parliament shall vacate his seat in Parliament. G, if he leaves the party of which he was a member at the time of his election to Parliament to join another party or seeks to remain in Parliament as an independent member. Or H, if he was elected a member of Parliament as an independent candidate and joins a political party, unquote. Honorable members, my humble view is that Article 97(1)(g) and H operate to prevent what the old school refers to as cross-carpeting or carpet crossing, as witnessed in the early legislative councils and parliaments of the Gold Coast and the Republic of Ghana, respectively. Cross-carpeting is now part of what is referred to as defection or party switching, when a member of Parliament who was elected on the ticket of one political party leaves that party to join another, or when an independent member of Parliament joins a political party after being elected as an independent member, or a party member acts similarly. The concept of defection raises significant concerns about the integrity of political representation. When voters elect a candidate, they do so based not only on the individual's personal qualities, but also on the political party platform they represent. Party switching or defection, therefore, can be seen as a breach of the mandate and social contract between the Member of Parliament and the electorate, as it changes the political dynamics that the voters originally endorsed. The prohibition of defection, as reflected in Article 97(1)(g) and (h), serves several critical purposes in maintaining the integrity of Parliament, parliamentarians, and protecting the trust and will of the people. The provisions of Article 97(1)(g) and (h) are designed to safeguard the principles of party loyalty, voter representation, and political stability. Defection is prohibited because it undermines the trust placed in members of Parliament by their constituents and can lead to instability in Parliament. These constitutional safeguards ensure that members of Parliament remain accountable to both their parties and the electorate, and they prevent members of Parliament from engaging in behavior that could amount to fraud or disruptive of the functioning of Parliament. Honorable members, it has been suggested by some members that the provisions of Article 97(1)(g) and (h), which address the vacating of a Member of Parliament seat due to defection, should be understood prospectively. That is, they should apply only to future parliaments and not to the term of office of Parliament when the act occurred. While this argument may appear to offer a practical approach, it must be firmly dismissed as both untenable and inconsistent with the constitutional purpose of these provisions. One may ask, what is Article 97 purposed to do? The clear intent of Article 97(1)(g) and (h), to my understanding, is to preserve party loyalty, engender trust, and protect the mandate of the voter and representation throughout the MP's term of office. These provisions are designed to prevent political instability, as I stated, opportunistic behavior, fraudulent representations, and disruption of parliamentary composition during the term of a parliament, by ensuring that members of Parliament remain faithful to the mandate given to them by the electorate at the time of their election. To understand these provisions as only applying prospectively, meaning that they will take effect only in future parliaments, will nullify the purpose of Article 97. The provisions of Article 97 and the consideration are intended to address breaches of party loyalty and independent status as they occur during a term, ensuring that the House's composition remains consistent with the electoral outcomes. If Article 97(1)(g) and (h) were to apply only in future parliaments, it will render these provisions effectively superfluous. By the time the next parliament is constituted, any member of Parliament who has defected or switched political allegiance during the current parliament will no longer be in violation of the provision. They will start the next term aligned with their new party or as an independent. There will exist no defection, and the violation will effectively be wiped clean at the start of the term of the succeeding parliament. If the understanding of the provisions was futuristic, members of Parliament could freely switch parties or become independent during the term of a parliament and pretend to be representing the interests of the people who elected him or her or the party on whose platform he or she rode to Parliament, while paying loyalty to a different party or group of people with no immediate consequences. This is precisely what Article 97(1)(g) and (h) are meant to prevent. The provisions exist to curb, as I stated, defection, as it happens, not to offer a free pass to members of parliament to change allegiance during their term and only face no consequences, even in future electoral cycles. Under Article 97 of the Constitution of Ghana, there are indeed different modes through which a member of parliament shall vacate his or her seat, and these can be broadly categorized into two groups. The A is the one that we refer to as automatic or procedural, and the B is a matter of determination of fact. Certain modes of vacating a seat happen automatically or procedurally, either through the direct operation of law or institutional processes. These are relatively straightforward and do not require external determination of facts. For example, the dissolution of Parliament, the election as Speaker, the expulsion for contempt, and resignation of a member of Parliament. The second category deals with others where you require determination of facts. And those are the other provisions identified in Articles 97(1), C, E, and D. These involve more complex factual situations that are less clear-cut and may be subject to dispute, making them matters that likely require determination to ascertain whether a vacancy has occurred. Honorable members, it is important to note that the determination of whether a member of parliament has resigned from their political party or has joined another party is a matter of fact. In 2020, during the tenure of Right Honorable Professor Aaron Michael Quay as Speaker of Parliament, a notable instance occurred when the New Patriotic Party notified the Speaker that the Member of Parliament for Formina, Honorable Andrews Asiema Amwako, was no longer a member of the party. The MPP requested that the seat be declared vacant in accordance with Article 97(1) of the Constitution, citing that the Member of Parliament had filed to contest the upcoming elections as an independent candidate, which violated the party's constitution. In response to this request and notification, Right Honorable Professor Aaron Michael Quay proceeded to declare the seat vacant. However, I must emphasize that this ruling made by the previous speaker does not bind other speakers, including myself. It is important to point out that in the present matter before the House, the notice of poll is available at the Electoral Commission on all the 275 constituencies. I have duly taken note of the notice of the poll, and furthermore, no member in making comments to the statement made to the House by the minority leader denies these glaring and notorious facts. And so, what is my role in all this? Honorable members, it is important to point out that the Speaker is called upon by the standing orders of Parliament, particularly Order 18, to inform the House of the occurrence of a vacancy of the seat of a member under Clause 1B to E, G, and H of Article 97 of the Constitution. Accordingly, I proceed to inform the House that by the notification of the polls, the following members of Parliament have by their actions vacated their seats in Parliament. The members are Honorable Peter Yao Kwache Aka, NDC MP for Amenfi Central in the Western Region, now referred to as an independent parliamentary candidate for the same constituency. 2, Honorable Andrew Amwako Asiama, independent member for Fomna constituency in Ashanti region, now referred to as MPP parliamentary candidate for the constituency. 3, Honorable Kojo Asante, MPP MP for Suhum in the Eastern region, now referred to as independent candidate for the same constituency. And finally, Honorable Cynthia Mamile Morrison, MPP MP for Akuna West constituency in the Central region, now referred to as independent candidate for the same constituency. These MPs cannot be allowed by law and my good self to continue to pretend to be representing people that they don't believe in and they don't have any loyalty for in this House any longer. The House is accordingly so informed. Honorable members, I thank you for your patience and attention. Honorable members, please. Honorable members, may we have some order in the House? Honorable members, this is my response to what happened 2 days ago, and I don't think this is subject to debate. It's a communication to the House, and by our standing orders, it's information I have to give you, and I've done so according to my understanding of the law. Please, Majority Leader.
Mr. Speaker, with respect, I thank you for the opportunity to make comments on the communication you have just delivered to the House.
May you kindly refer to the standing orders that you are coming under.
Mr. Speaker, I do not come under any standing orders.
So you may resume your seat then.
Mr. Speaker, you are the father of this House. And Mr. Speaker, you have communicated to the House a position you've taken. It's been our practice that any time you have come out with a formal communication, you give opportunity to leadership to make a response. Mr. Speaker, if today you do not want me to talk, Mr. Speaker, that should be it. But Mr. Speaker, if you say that...
Honorable member, you got it wrong. It's not the practice of the House that any time I come with a formal communication, allow members to make comments. That's not the practice of the House. It's never been the practice of any of the houses that I have been member from 1993 to date. I have not had that as any practice of the House. Some speakers, including myself, may entertain some comments from members, but it is not a practice of the House.
Mr. Speaker, if it pleases you, I would like to make some few comments on the matters you've raised, because, Mr. Speaker, these are very grave matters. The matters you've raised are not light matters. They are very grave matters that I would want to comment. And, Mr. Speaker,
so
please,
you want to seek my leave to make comments?
that is so, respectfully.
Now you agree it's not the practice,
Mr.
but you are
Speaker,
just seeking my leave.
Mr. Speaker, as it pleases you, with your leave. With your leave.
Well, yes, you may do so.
Mr. Speaker, thank you once again for the leave granted me to comment on your communication you just delivered. Mr. Speaker, you underscored your submissions with a very important point, that the matter that came before us has interpretation reliefs, and that you do not have the power to interpret the Constitution, and that your duty is to enforce. Mr. Speaker.
Honourable member, you are not listening to me.
Mr. Speaker, may I finish with respect?
All what you said are wrong, so
Mr.
I
Speaker,
cannot continue to allow you to keep on misleading the House.
Mr. Speaker, please, if you think that this is your house and you didn't want us to talk, so Mr. Speaker, we should allow you to
Honourable
speak.
Majority Leader, you are addressing the Speaker.
Mr. Speaker, you may.
Please.
I need your protection. They must stop what they are doing.
I'm in charge.
Mr. Speaker, then they may
Anytime.
be quiet.
Please.
Mr. Speaker, with respect, in your ruling, my understanding was to the effect that your duty is not to interpret the Constitution. My understanding was to the effect that your duty is not to interpret the Constitution. But, Mr. Speaker, it is important for me to emphasize one more time that when the statement was made by my respected colleague, Dr. Kesil Atufosin, I did draw the attention of the House, including your good self, to the effect that the matter being a very grave matter, I have taken it upon myself to seek the court's interpretation of the matter. Mr. Speaker, indeed. Mr. Speaker, I think
Honourable
I deserve some
members,
respect.
please,
Mr. Speaker,
let's listen
I think
to
I
each other.
deserve some respect.
Let's listen to each other.
No,
please.
I think it is only fair.
Honourable Majority Leader, please address me. I'm taking care of that. Please,
Mr.
let's
Speaker,
listen to each other.
I did indicate that I have filed a process at the Supreme Court. And indeed, Mr. Speaker, the bailiff of the court had attempted to serve the process on the Director of Legal Affairs, and the Director of Legal Affairs and the entire legal directorate refused service because, according to them, there was a circular stating that they can only be served on Mondays. I saw the circular myself. Subsequent to that, I explained, hearing the intention of Mr. Speaker to come to a determination in one way or the other, the directed service, which is within my rights. Mr. Speaker, yesterday, Parliament was duly served.
Honourable member, please, I didn't want to interrupt you, but you are the majority leader and the leader of this House. As at the time you were directing service yourself you took the trouble of coming to Parliament with two persons who are alleged to be bailiffs and went to the legal office to yourself, directing officials of the legal office to receive the service. You are a member of Parliament. I am the Speaker. It is my duty to protect your privileges and immunities. In doing so, I had a discussion with the Chief Justice, and we came to an understanding that in the meantime, the Chief Justice issued a directive as to how service of members of Parliament, some officers of Parliament, and the Speaker could be effected. I communicated this to the House and discussed it with you, the leaders. We said that as we go along, we will together, Parliament and the Judiciary, particularly led by the Supreme Court, come out with a legislation on this issue of privileges and immunities of Parliament, members of Parliament, and specified officials of Parliament. We discussed this. Based on this discussion, the Chief Justice issued a directive to all registries of courts in the country. And it is stated clearly there that the Speaker can be served on Mondays during working hours. There were reasons why we came to those agreements. You are aware of it. Yet you kept on insisting that service be effected whilst the Speaker was presiding over the proceedings of the House. You, as leader of the House, as majority leader, you are saying that this was service because you threw the court processes on the table and walked away. Is that how you effect service? Please, to quote the common parlance, don't go there.
With respect, for the past 12 years, I have accorded you every respect, and I'll continue to do that. Mr. Speaker, the facts you put out are not true. Mr. Speaker, these are credibility issues, so I will respond for the record. Mr. Speaker, somebody has told you something. Mr. Speaker, you reserve the right to be there to make your point. Let me make my point too. Mr. Speaker, no way. Mr. Speaker, no way. Mr. Speaker, whoever told you, Mr. Speaker, whoever told you that I threw a paper at somebody, this has to do with my credibility. I will not allow hands.
No, honorable member, you don't listen at all.
Mr. Speaker, I do.
I never said
Mr.
you.
Speaker, you said
I never said you threw a paper at anybody.
Mr. Speaker,
I never
Mr.
said
Speaker,
that.
that's exactly what you said. Let the answer check it.
You
Mr.
see,
Speaker, that is what you said.
You are being carried away by your
Mr.
anger.
Speaker,
You are not listening.
Mr. Speaker, I'm not angry at
Honorable
all.
member. Honorable member.
Mr. Speaker, I'm not angry.
I said the court process was thrown on the table in the office. I never stated it was thrown by you at any person.
Mr. Speaker, you said I allegedly said some bailiffs. Alleged bailiffs.
No.
Mr. Speaker, then clarify.
Please.
Mr. Speaker, with
Listen
respect,
to me.
Mr. Speaker, I'm listening.
Honorable Majority Leader, I don't want to proceed to make some orders. Please, resume your seat. I'm very serious about that.
Mr. Speaker.
Please, resume your seat. Honorable member, your
Coming events cast their shadows. We have Parliament now, elect with the executive.